documents, it feels like you need some kind of secret decoder ring just to figure out what they're actually saying.
Uh-huh. Definitely dense stuff sometimes.
Right. Well, today we're doing that decoding for you. We're cutting straight to the heart of some really, truly groundbreaking legal changes happening in India.
Hmm.
Because, let's face it, when it comes to the safety, the dignity of women and children, understanding the legal landscape, well, it isn't just for lawyers, is it? It's absolutely vital for all of us.
Absolutely essential.
So our deep dive today takes us into the recently enacted Bhartiya Nyaya Sanhita 2023. Let's just call it the BNS for short, okay?
Good idea, yeah. BNS.
And this isn't just some minor tweak, it's a comprehensive overhaul of really significant parts of India's criminal code, especially those chapters dealing with offenses against woman and child.
That's right. Chapter 5 and parts of Chapter 6.
Exactly. So our mission today, basically to unpack how this new legal framework defines, punishes, and hopefully aims to prevent some of the most awful crimes against these vulnerable groups. And importantly, what these changes actually mean in practical terms.
Indeed. And we're drawing directly from detailed legal commentary on the BNS itself, analyzing these key provisions, sections 63 through 99 primarily.
Okay.
What's really striking, I think, is how the Sanhita tries to modernize and expand on those, let's say, traditional definitions of offenses.
Yeah.
It often reflects years of, judicial evolution, court decisions, and also those powerful societal demands for stronger protections.
Right. So it didn't just appear out of nowhere.
Not at all. While it is a new law, its principles are, well, deeply rooted in existing legal thinking in jurisprudence. So that lets us connect the dots, look back at previous interpretations and really grasp the why behind these legislative choices.
Now, you might be sitting there wondering, okay, a law from India. Why does that matter to me right here, right now? Fair question, right? Well, the thing is, these principles, justice, consent, bodily autonomy, child protection, they're universal. Every society, everywhere, grapples with these issues.
They really do.
So understanding how a major legal system like India's addresses these challenges, well, it offers profound insights into those global efforts for human rights and how laws adapt or try to adapt to meet evolving social needs.
That's a great way to put it.
Okay, so let's pull back the curtain then. Let's really dig into these changes, starting with one of the most fundamental, I think, the very definition of rape itself. #1, defining sexual violation and punishments under the BNS 2023.
Okay, let's jump straight into Section 63 of the BNS. This is really where we see a major shift, isn't it? The definition of rape itself.
Yes, absolutely. It's not just a rehash of the old Indian Penal Code. It significantly expands the traditional understanding.
Expands how? Because for years, legal definitions often felt quite narrow, didn't they? Focused on one specific act. Exactly. This new law aims for a much more comprehensive understanding of what constitutes sexual violation. It moves beyond just penile vaginal penetration.
So what's the core idea driving this expansion?
Well, the core insight, I'd say, is placing the woman's right to choose her autonomy right at the absolute center. It moves away from some, frankly, outdated notions of what counts as a sexual act.
And instead focuses on the violation itself.
Precisely. The violation of any non-consensual penetration. It's fundamentally about protecting a woman's sexual autonomy, her bodily integrity, and her basic human dignity. Section 63 clearly outlines what valid consent looks like, and crucially, when consent is negated or simply wasn't there in the first place.
Okay.
And this expansion of the actus reus, that's the legal term for the criminal act itself.
Right, okay.
It reflects a much more nuanced understanding of sexual assault. It recognizes that violation isn't limited to just one specific action. And if you connect this to global legal trends, you see it moving towards alignment with international standards, which define sexual assault much more broadly.
So it acknowledges the different ways violations can happen.
Yes. Acknowledging the diverse and often, frankly, harrowing ways a person's bodily autonomy can be violated. It's a really significant step, I think, in making the law both comprehensive and genuinely sensitive to the victim's experience.
Okay, so let's break down those expanded acts. What does it actually cover now?
Right. Well, it covers the, let's say, traditionally understood act, penile penetration into the vagina, mouth, urethra, or anus of a woman, or making her do the same with him or another person.
Okay, that's fairly standard, but where does it broaden out?
Here's where it gets significantly broader. It also includes the insertion, even to the slightest extent, of any object or a part of the body that isn't the penis.
Any object.
Any object, yes, or a non-penile body part, into the vagina, urethra, or anus of a woman, or, again, making her do so.
Wow, okay. That's a big change.
It is. And it goes further still. It also criminalizes the manipulation of any part of the body of a woman so as to cause penetration into her vagina, urethra, anus, or, and this is very broad, any part of her body.
Any part of her body. That seems incredibly inclusive.
It's designed to be. It moves beyond just the typical orifices to protect against a wider range of physical violations. And finally, it specifically addresses the application of a man's mouth to the vagina, anus, or urethra of a woman, or making her do so.
So a very wide net for the physical acts. Now, what about the consent aspect, the mens rea or the mental state?
Right. Beyond the physical act, the law specifies several crucial conditions where consent is simply absent or effectively negated. This addresses that mental aspect, or rather, the lack of genuine willingness from the victim.
Okay, like what?
Well, obviously the fundamental ones. If the act is against her will or without her consent, that's the baseline.
Sure.
But it also explicitly includes situations where consent is obtained through fear of death or serious harm, either to her or to someone she cares about. That tackles clear coercion.
Makes sense. What else?
What's crucial here is how the law gets into the nuances of consent. It recognizes that a yes, under duress or deception, isn't a real yes. For instance, consent given because a woman mistakenly believes the man is her lawfully married husband, and he knows she believes this. That's explicitly invalid consent. It addresses a very specific kind of identity fraud within relationships.
Interesting. And what about vulnerability?
Absolutely key. The law is unambiguous. If a woman is under 18 years of age, there is no legal capacity to consent, period. Regardless of what she might say or do, it's an absolute shield for minors.
Strict liability there.
Correct. And it also covers situations where she's simply unable to communicate consent. Maybe she's unconscious or has certain disabilities preventing her from expressing her will. These are critical protections for the most vulnerable.
So the law tries to be very clear on what real consent actually means.
Yes, very. It defines it as an unequivocal voluntary agreement, and it specifies this agreement can be communicated through words, gestures, or any form of verbal or nonverbal communication. Crucially, it must express willingness to participate in the specific sexual act, not just general willingness, but for that particular act.
The specificity is important.
Very. And here's a really powerful addition to the proviso. It states that a woman who does not physically resist shall not, simply because of that lack of resistance, be regarded as consenting.
That tackles the old, awful myth about victims needing to fight back, doesn't it?
Precisely. It raises that vital point about passive submission versus active consent. It unequivocally shifts the onus onto the perpetrator and basically codifies what courts have been emphasizing for years. Mere passive submission is never consent. There has to be that active, unequivocal, voluntary agreement.
Okay, now, let's get to a point that, well, often sparks a lot of debate and has a really complex history. The marital rape exception, or MRE. What does the BNS say here?
This is often contentious. Section 63 states that sexual intercourse or sexual acts by a man with his own wife, provided the wife is not under 18 years of age, is not legally considered rape under this specific section.
So the exception remains for adult wives.
Yes, the retention of the MRE for wives over 18 is definitely a point of significant legal and social debate. It reflects these ongoing, very complex discussions within the legal framework about, well, conjugal rights versus individual autonomy within a marriage.
Hasn't this been challenged in courts before?
Oh, yes. Indian jurisprudence has seen progressive challenges. There were even rulings that effectively read down the exception, criminalizing it for wives between 15 and 18. But the BNS, as enacted, maintains the exception for adult wives over 18.
So it's still an evolving area.
Absolutely. The very existence of this exception really underscores that the journey towards full recognition of marital sexual autonomy, especially within the specific social and legal context of diverse societies like India, well, that journey is still ongoing and subject to intense scrutiny and debate.
Okay, so we've defined the acts. Now let's move from definition to consequences. The punishments. Section 64 breaks these down, right?
That's right. And you see a clear distinction based on the severity and the circumstances of the crime.
What's the overall aim?
The law aims for stringent punishments across the board, but with significantly enhanced penalties for what it terms aggravated forms of rape. Things like abuse of authority, extreme brutality, or repeat offenses. The goal is clearly strong deterrence and unequivocal justice.
So what's the baseline punishment for general rape?
For what Section 64(1) covers, the general offense, the minimum is rigorous imprisonment for at least 10 years. That can be extended up to life imprisonment, and there's also a fine. So a very serious starting point.
Okay. And then the aggravated forms in subsection 2, What makes a rape aggravated?
Several things. It includes crimes committed by people in positions of power or trust. Think police officers, especially if the act happens in custody or within station limits. Public servants dealing with people in custody, armed forces, members in deployed areas, or staff in institutions like jails, remand homes, hospitals, women's or children's homes, preying on inmates or patients.
Abuse of power, essentially.
Exactly. It also covers situations where the victim is particularly vulnerable, already in custody, an inmate, a patient, or if the perpetrator is a relative, guardian, teacher, or someone in a position of trust or authority over the woman.
What else falls under aggravated?
Victim vulnerability also includes cases where the woman is known to be pregnant, incapable of giving consent, like due to disability, or if the perpetrator is in a position of control or dominance over her.
Okay.
Then there's extreme brutality acts causing grievous bodily harm, maiming, disfiguring, or endangering the victim's life. It also specifically includes rapes committed during communal or sectarian violence, and importantly, recidivism, repeated rape on the same woman. That acknowledges the compounded trauma.
And the punishment for these aggravated forms, is it significantly higher?
Yes, rigorous imprisonment for not less than 10 years, but extendable to imprisonment for life, which, and this is explicitly defined, shall mean imprisonment for the remainder of that person's natural life, plus a fine.
Right, that remainder of natural life clause again. You mentioned its impact earlier. What's the significance of spelling it out like that?
Its real impact is that it significantly limits the government's power to grant remission or reduce the sentence later on. It essentially ensures these offenders serve their full life term. This principle has been upheld in landmark cases, and it sends a very clear signal of zero tolerance for these most severe forms of the crime.
So it's about ensuring the sentence sticks.
Exactly. The legal theory behind it involved proportionality, making the punishment fit the extreme gravity of the crime, and also the robust protection of vulnerable groups, which is really a core principle in modern criminal justice.
Okay, now let's turn to the protection of the most vulnerable children. Section 65. This must reflect society's strongest condemnation, right?
Absolutely. The law imposes exceptionally stringent punishments here, recognizing the profound, lifelong trauma, physical, psychological, emotional, inflicted on child victims. The object is clearly strong deterrence and the most severe consequences possible, including the possibility of the death penalty for the very youngest victims.
So let's break it down. Rape of a woman under 16.
Right, under 16. The minimum punishment is rigorous imprisonment for at least 20 years. That can extend to imprisonment for life, and again, that means for the remainder of the person's natural life, plus a fine.
20 years minimum. That's incredibly high.
It is. And the law adds those crucial provisos about the fine. It must be just and reasonable to cover the victim's medical expenses and rehabilitation needs. And importantly, it has to be paid directly to the victim.
That victim-centric approach again, that seems like a really positive shift, focusing on repair.
It is. It's a key aspect of restorative justice principles finding their way into the punitive framework, moving beyond just punishment to directly address the harm and hopefully aid the victim's recovery.
Okay, and what about the rape of a child under 12 years old?
For a child under 12, the punishment is even more severe. Rigorous imprisonment for at least 20 years, extending up to life imprisonment for natural life, ADA fine, or the death penalty.
Death penalty as an option.
Yes, the same victim-centric fine provisions apply as well. But the provision for the death penalty here is a very stark reflection of societal abhorrence for such crimes. It squarely places these acts within the rarest of rare doctrine used for capital punishment in India, a principle that's been upheld even for minors under similar laws, like the POCSO Act, the Protection of Children from Sexual Offenses Act.
So essentially zero tolerance.
Zero tolerance. It signals the legislative intent to provide the absolute strongest possible protections for children who are deemed exceptionally vulnerable. Extremely high mandatory minimums, the life for natural life clause, and the death penalty option send that message unequivocally.
Now, what happens when these horrific crimes don't just violate but, well, irrevocably destroy life, or the very essence of it? Section 66 seems to address those extreme outcomes.
That's exactly right. It imposes the most severe punishments for rape that culminates in the victim's death, or reduces them to what's called a persistent vegetative state, or PVS. The object is clear. Meet such extreme brutality with the harshest possible sanctions, again, including the death penalty.
So what's the specific scenario covered here?
It applies when an accused commits rape under either the general or aggravated definitions we discussed, and in the course of that crime inflicts an injury that either causes the woman's death or causes her to end up in a persistent vegetative state.
And the punishment reflects that extreme outcome.
Absolutely. Rigorous imprisonment for at least 20 years, extendable to imprisonment for life, meaning the remainder of natural life, or the death penalty.
The inclusion of persistent vegetative state seems significant. Why single that out?
It is highly significant. Nudgel discussions in jurisprudence, perhaps most famously in the tragic Aruna Shanbog case in India, have really highlighted the profound and permanent incapacitation that comes with PVS. This section essentially equates the gravity of causing PVS with causing death, at least for sentencing purposes.
So it recognizes that the life, as lived, is effectively over.
Exactly. It recognizes that life, in terms of consciousness and function, effectively ends, even if the body continues. Connecting this to the bigger picture, it really underscores the holistic value the law places on a person's life and consciousness. It applies legal principles like aggravated culpability and proportionality to these most severe forms of harm imaginable. #tag 2, specific sexual offenses and exploitation.
Okay, we just talked about the marital rape exception, but you mentioned nuances. Section 67 seems to introduce one, right? Specifically about couples living separately.
Yes, exactly. This provides a limited but important recognition of wife's sexual autonomy within a marriage, but specifically when the spouses are living separately.
So it criminalizes non-consensual sex by a husband in that specific situation.
Correct. It criminalizes non-consensual sexual acts by a husband when they are living separately, offering protection against marital sexual violence outside the typical cohabitation norm. Importantly, though, it does this without removing the broader marital rape exception for cohabiting couples we discussed in Section 63.
Okay, so what are the key elements here?
The ingredients are clear. A husband has sexual intercourse defined broadly, as per Section 63, with his own wife who is living separately. Now, that separation isn't just, say, a business trip. It can be under a formal judicial decree or otherwise, which implies even a de facto separation. And crucially, it must be without her consent.
And the punishment.
Imprisonment for not less than 2 years, which can extend up to 7 years, plus a fine.
This feels like a step, maybe a small one, towards recognizing autonomy even within marriage.
It is. It's a step towards recognizing a wife's individual sexual autonomy, particularly when those implicit assumptions about conjugal rights that might exist in a cohabiting marriage are altered by the act of separation.
It does raise a question, though. How is living separately interpreted?
That's a key question. Courts traditionally look beyond just temporary absence. They usually look for a cessation of cohabitation combined with an intent to live apart. So it represents a kind of partial dilution of the MRE, acknowledging that consent remains paramount once the marital unit is physically estranged.
Okay, moving on. Beyond direct rape, there's this insidious form of exploitation involving abuse of power. Section 68 seems to tackle that.
Yes, it addresses the abuse of power or trust directly. It targets individuals in positions of authority, think public servants, hospital staff, jail superintendents, who abuse their position to obtain sexual intercourse from vulnerable women under their charge or care.
So it's about exploiting that power imbalance.
Precisely. It criminalizes exploitative sexual acts that might not technically meet all the strict ingredients for rape, as defined in Section 63, but are still reprehensible because of that inherent power imbalance.
What's the specific scenario?
The scenario is this. An accused person is in a position of authority or holds a fiduciary relationship, a position of trust. They abuse that position to induce or seduce a woman who might be in their custody, under their charge, or simply on the premises they control, into having sexual intercourse. And here's the key part. Such sexual intercourse does not amount to rape under Section 63.
Ah, okay, so it fills a gap.
Exactly. What's fascinating here is how this section plugs that potential gap. It covers situations where, technically, formal consent might have been given, but it was given within a coercive environment created by that power dynamic. It doesn't quite fit the specific circumstances like fear of death or hurt that negate consent for rape under Section 63.
So it's a tool against more subtle exploitation.
Yes. A critical tool against subtle yet profound exploitation, where the victim's vulnerability, stemming directly from that power imbalance, means their consent wasn't truly free and voluntary, even if not explicitly extracted through overt threats or violence. It criminalizes the abuse of trust itself, which is often a silent, hidden enabler of sexual exploitation.
And the punishment reflects this seriousness.
Rigorous imprisonment for not less than 5 years, extendable up to 10 years, plus a fine. So still very significant penalties.
Okay, what about situations where consent is given, but it's based on a lie? a really deep deception. Section 69 seems to get into this.
Yes, this section penalizes sexual intercourse obtained through specific forms of deception. The law calls it deceitful means.
What counts as deceitful means?
The law gives examples: making false promises of employment or promotion, or suppressing crucial identity details like your marital status, religion, or caste to induce consent.
And the false promise to marry, that comes up a lot.
It does. And Section 69 explicitly covers a false promise to marry made without any intention of fulfilling it. That's a key distinction.
Right, not just a promise broken later, but one that was never intended to be kept.
Exactly. And the law qualifies this.
Yeah.
Such sexual intercourse obtained through these deceitful means does not amount to the offense of rape as defined back in Section 63.
So it's a separate offense.
It's a distinct offense, yes.
Sure.
The punishment is imprisonment up to 10 years and a fine.
This feels like it directly addresses those really contentious false promise to marry cases we hear about.
It does. Courts have struggled for a long time to distinguish between a genuine promise that's later broken, which is usually a civil matter, maybe a breach of promise, and a promise that was false from the very beginning, used specifically to obtain consent for sex.
So the BNS gives this a clearer legal footing.
Yes, it provides specific statutory footing. It recognizes that consent obtained through such fundamental deceit about something as significant as marriage or employment isn't truly free and informed consent, even if it doesn't meet the high bar for negating consent required for a rape charge under Section 63, which deals with consent obtained by fraud regarding the nature of the act or identity.
Yeah.
It essentially criminalizes this specific kind of exploitation through lies.
Now, when multiple people conspire to commit sexual assault, the law seems to recognize that as an even deeper level of criminality. Section 70 on gang rape.
Yes. Section 70 acknowledges the severely aggravated nature of rape committed by multiple perpetrators acting together, in concert. It imposes extremely severe punishments.
Why the harsher penalties?
It reflects the enhanced trauma often associated with such attacks, and also the profound societal abhorrence for this kind of collective violence. And the penalties get even harsher, including the possibility of death if the victim is a minor.
So what's the basic situation defined here?
A woman is raped by one or more persons constituting a group or acting in furtherance of a common intention. The law is very clear. Each person involved is deemed to have committed the offense of rape.
Even if they didn't all physically commit the penetration.
That's the crucial point.
Yeah.
Even if not all individuals physically committed penetrative acts, their participation in furtherance of that common intention makes them equally guilty of the crime itself.
And the punishments.
For an adult victim, rigorous imprisonment for not less than 20 years, extendable to imprisonment for life, meaning the remainder of natural life, and that victim-centric fine we discussed earlier.
20 years minimum again.
Yes. And if the victim is under 18 years old, the punishment is imprisonment for life, remainder of natural life, and the fine or the death penalty.
So how does this common intention principle work legally?
It applies the principle of joint liability, much like in other serious crimes committed by multiple people acting together with a shared criminal goal, a common intention. What's particularly impactful here is holding all members of the group equally culpable. Their act of participation, furthering that shared intent to commit the assault, is enough. It reflects the collective terror and the unique, profound trauma inflicted in gang rape situations. It's a very strong affirmation of society's harshest condemnation for such collective brutality. #3, victim protection, modesty, and harassment.
Okay, let's talk about repeat offenders. If someone commits these awful crimes once and then goes on to do it again, what does the law say? Section 71 seems designed for this.
Yes, Section 71 mandates exceptionally severe punishment for individuals who are repeat offenders of certain very specific, grave sexual offenses.
Which offenses exactly?
It lists them.
Yeah.
Rape, S64, aggravated rape, rape of minors, S65, rape causing death, or PVS, or gang rape, S70.
Okay, the most serious ones.
Exactly. The object here is clearly maximum deterrence and, frankly, incapacitation of habitual offenders who commit these specific crimes.
So what's the trigger?
The situation is straightforward. An accused person has a previous conviction under any of those sections we just listed, 64, 65, 66, or 70, and is subsequently convicted of an offense under any of those same sections again.
And the punishment.
It leaves absolutely no room for judicial discretion on the minimum. The punishment is imprisonment for life, explicitly meaning for the remainder of that person's natural life or the death penalty. There is no lesser option provided.
Wow. So it's basically 2 strikes and you're facing natural life or death for these specific crimes.
That's a way to think about it, yes. It's a form of 2 strikes or 3 strikes philosophy, but very narrowly targeted at these specific, extremely grave sexual offenses. It removed the judge's ability to give a lesser sentence, making it clear that repeat offenders of these particular crimes face one of two outcomes: natural life imprisonment or capital punishment.
It does raise questions about rehabilitation versus retribution, doesn't it?
It absolutely does. It raises that important question about balancing strict retributive justice with any potential, however slim, for reform. But the legislative intent here seems unambiguous. Prioritize incapacitation and permanently remove individuals convicted repeatedly of these specific heinous crimes from society.
Moving on. Beyond the physical harm, sexual offenses inflict deep social and emotional wounds. The next section, Section 72, seems aimed at preventing further victimization by protecting the victim's identity.
Precisely. Section 72 criminalizes the disclosure of the identity of victims of those specified sexual offenses we've been discussing, Section 64 through 71. The entire point is to prevent further trauma, avoid social stigmatization, and hopefully encourage victims to report these crimes without the added fear of public exposure and shaming.
So what exactly is prohibited?
The prohibited act is printing or publishing the name of the victim, or really any matter which might make their identity known.
Any matter? That sounds quite broad.
It is intended to be broad. The punishment is imprisonment for up to 2 years and a fine.
Are there any exceptions for investigations, for example?
Yes, but they are very strict exceptions. Disclosure is allowed for the purpose of investigation, but only under a written order from the officer in charge of the police station, and it must be done in good faith.
Okay. What about the victim themselves?
The victim can give written authorization for their identity to be disclosed.
And if the victim can't authorize it, say if they're a child or deceased?
If the victim is dead, a child, or of unsound mind, the next of kin can give written authorization. But, and this is a crucial restriction, that authorization only allows disclosure to a recognized welfare institution or organization, not to the general public or media.
Ah, so it controls who gets the information even then.
Exactly. It prevents others from potentially exploiting a vulnerable victim's identity or situation. This provision strongly supports the victim's fundamental right to privacy, which courts have increasingly recognized as part of the broader right to life and dignity.
That broad interpretation of any matter which may make known the identity seems key.
It is. What's particularly insightful is that precise control over disclosure. Jurisprudence over the years has emphasized a broad interpretation. It's not just the name, but could include details like address, family names, workplace, school, anything that could lead to identification. It's a vital shield against re-victimization through public exposure, allowing victims space to heal without facing further societal judgment.
And extending that protection, even the court proceedings themselves have strict rules, right? Section 73?
Yes, Section 73 regulates the publication of court proceedings related to these same sexual offenses covered by Section 72. It requires prior permission from the court before publishing anything about the proceedings.
What's the goal here? Balancing open justice and privacy.
Exactly. The object is twofold: prevent the indirect identification of the victim through reporting on the case, and ensure that the proceedings are reported sensitively. It balances the important principle of open justice with the absolute necessity of protecting the victim's privacy.
So what's forbidden without permission?
Printing or publishing any matter relating to the court proceedings for these specific offenses, those listed in S-72, without getting previous permission from the court.
And the penalty?
The same as for disclosing identity: imprisonment up to 2 years and a fine.
Is there an exception for, say, publishing the final court judgment?
Yes. The publication of judgments from any high court or the Supreme Court is not an offense under this section. Though in practice, the courts themselves almost always anonymize judgments in these sensitive cases to protect victim identity.
So it's about managing information flow carefully.
Precisely. It's about managing public information in these highly sensitive cases. It upholds the principle of open justice, allowing reporting, but only with judicial oversight. The court can impose conditions, like requiring anonymization. If you connect this to the bigger picture, it really reflects how legal systems are constantly evolving to better protect vulnerable individuals while still maintaining a transparent judicial process.
Okay, let's shift gears slightly. Moving to acts that, while maybe not rape, are still deeply offensive and violate a woman's dignity. Section 74 talks about assault or criminal force with intent to outrage modesty.
That's right. This section criminalizes assault or the use of criminal force against a woman when the perpetrator has the specific intent to outrage her modesty.
What's the aim? Protecting dignity.
Essentially, yes. The object is to protect a woman's sense of decency and decorum. It penalizes acts done with the intention of outraging that sense of modesty or with the knowledge that such outrage is likely.
So what are the basic ingredients?
An accused person assaults a woman or uses criminal force against her. And crucially, they do this intending to outrage her modesty or knowing it's likely that their actions will outrage her modesty.
And the punishment?
Imprisonment for not less than 1 year, which can extend up to 5 years plus a fine.
The term modesty itself seems a bit subjective. How's it usually interpreted?
That's a key point. Modesty here is often interpreted by courts not just as an individual feeling, but as an attribute associated with female human beings as a class. The focus is on whether the act itself is capable of shocking a woman's sense of decency.
So it's about the intent behind the act.
Yes. This raises that important question about the subjective nature of modesty versus the objective intent of the perpetrator. The courts tend to focus heavily on proving that culpable intention, the intent to outrage, was present.
Okay, next up, sexual harassment, Section 75. This is another area that's seen huge public discussion and calls for really clear legal definitions.
Absolutely. And Section 75 attempts to provide that clarity by criminalizing specific unwelcome acts of a sexual nature that cause harassment to women. These can be physical, verbal, or even visual acts.
What's the core objective?
To protect women's dignity, their personal space, and fundamentally, their right to live and work free from unwelcome conduct of a sexual nature.
So what specific acts does the law list? It mentions acts by a man against a woman.
Right. It specifies 4 categories. First, physical contact and advances that involve unwelcome and explicit sexual overtures.
Okay.
Second, making a demand or request for sexual favors.
Right. Quid pro quo type situations often fall here?
Potentially, yes. Third, showing pornography to a woman against her will.
Okay.
And fourth, making sexually colored remarks.
And are the punishments different for these?
Yes. The punishments are tiered. For the first 3 physical contact advances, demand for favors, showing porn, it's rigorous imprisonment for up to 3 years, or a fine, or both.
And for the remarks?
For the 4th category, making sexually colored remarks, the punishment is imprisonment for up to 1 year, or a fine, or both, a slightly lower penalty, but still criminalizing it.
This feels very specific, very codified.
It is. What's truly insightful here is how precisely these acts are codified. They directly reflect the guidelines that emerged from landmark court cases, particularly the Jashaka v. State of Rajasthan judgment from the Supreme Court decades ago, which laid down foundational principles for preventing workplace sexual harassment.
And that word unwelcome seems critical.
Absolutely crucial. The emphasis throughout is on the act being unwelcome. This makes the victim's perspective, whether she perceived the conduct as unwelcome, a central consideration. This comprehensive detailing provides a clear statutory basis, ensuring various forms of sexual harassment are recognized and penalized, bringing much-needed legal clarity.
Now, there are acts designed not just to insult, but to, well, profoundly humiliate and degrade someone. Section 76 seems to cover this. Assault with intent to disrobe.
Yes, exactly. Section 76 specifically criminalizes assaulting or using criminal force against a woman with the specific intention of disrobing her or compelling her to be naked.
What's the aim here? Deterrence.
Yes, the object is to deter these particularly outrageous acts which are clearly intended to humiliate, degrade, and intimidate the victim.
So what are the basics?
An accused person assaults a woman, uses criminal force against her, or even abets someone else doing so. The key is the intention. The act must be done with the intention of disrobing her or compelling her to be naked.
And the punishment reflects that severity.
It does. Imprisonment for not less than 3 years, extendable up to 7 years, plus a fine.
This seems distinct from just general assault where clothes might get torn.
Absolutely. This section targets a particularly egregious form of outraging modesty. That specific intent to disrobe is paramount here. It differentiates it from, say, a general scuffle where clothing might accidentally tear. The law recognizes the extreme psychological trauma and humiliation caused by forced nudity and imposes a significant penalty accordingly.
Okay, in our, hyper-connected world, privacy violations have taken on these new, really insidious forms, especially with technology. Section 77 on voyeurism, this seems very relevant today.
Extremely relevant. Section 77 criminalizes 2 main things. First, watching or capturing images of a woman engaging in a private act without her consent. Second, disseminating such images, again without consent.
What's the goal? Protecting privacy.
Yes. The aim is to protect a woman's privacy against intrusive visual observation or recording, especially in intimate situations where she has a reasonable expectation of privacy. and, crucially, to penalize the non-consensual dissemination or sharing of those images.
Okay, so what counts as a private act?
The law defines it quite clearly. It's an act where she would reasonably expect privacy. Examples include situations where her genitals or breasts are exposed or covered only by underwear, or when she's using a lavatory, or engaged in a sexual act that wouldn't normally be done in public.
Right. Now, you mentioned dissemination. There's a key nuance here, isn't there? About initial consent versus consent to share.
Yes, and this is a huge point, often an aha moment for people. The law states that even if the victim consented to the image being captured initially.
Like in a relationship, maybe.
Exactly. But if she did not consent to it being disseminated or shared later, then that act of dissemination is still a criminal offense under this section.
That directly hits revenge porn and non-consensual sharing of intimate images, doesn't it?
Absolutely. It's a significant development, providing clear legal recourse against this specific type of harm.
And the punishment, is it graded?
Yes, it's graded for repeat offenses. For a first conviction, imprisonment for not less than 1 year, extendable up to 3 years, plus a fine.
Yeah.
For a second or subsequent conviction, the penalty increases. Imprisonment for not less than 3 years, extendable up to 7 years, plus a fine, reflecting greater severity for recidivism.
That reasonable expectation of privacy seems foundational here.
It is the cornerstone. And that explicit criminalization of dissemination, even if the initial capture was consensual but the sharing wasn't, truly reflects the modern challenges of image-based sexual abuse. If you connect this to the bigger picture, it's a direct legal response to the digital age's capacity for profound privacy violations and the severe emotional, psychological, and reputational harm they cause.
And then there's stalking, Section 78. From, physical following to relentless digital monitoring, stalking can be terrifyingly pervasive.
It really can be. Section 78 criminalizes that persistent and unwelcome pattern of following, contacting, or monitoring a woman, which causes her alarm, distress, or fear.
What's the objective? Protection from harassment.
Yes. To protect women from harassment that intrudes upon their privacy, curtails their freedom of movement and peace of mind, and worryingly can sometimes escalate to more serious violence.
So, how does the law define stalking? What acts are covered?
It defines stalking, committed by any man against a woman, in 2 main ways. First, if he follows a woman and contacts her, or attempts to contact her, repeatedly, despite a clear indication of disinterest from her. The repetition and the ignoring of disinterest are key.
Okay, that's the more physical following aspect. What about online?
And this is the major modern inclusion. The second definition covers monitoring a woman's use of the internet, email, or any other form of electronic communication. Essentially, cyberstalking.
That's huge, recognizing the digital dimension.
Absolutely. What's truly insightful here is that explicit inclusion of cyberstalking. It's a clear recognition of how technology is often used to facilitate this insidious form of harassment.
That phrase, clear indication of disinterest, seems important too.
It's vital. It empowers the victim's voice and puts the responsibility on the perpetrator to stop once disinterest is shown.
Are there any exceptions, legitimate reasons for monitoring?
Yes. The law provides exceptions if the accused can prove their conduct fell into 1 of 3 categories. It was for preventing or detecting crime, and they were entrusted by the state to do so. It was done pursuant to any law or legal requirement, or, more broadly, that the conduct was reasonable and justified in the specific circumstances.
How easy is it to prove those exceptions?
That raises an important question. Courts typically interpret these exceptions, especially the reasonable and justified one, quite strictly, requiring a very high threshold of proof from the accused. It acknowledges that stalking, whether physical or digital, causes immense psychological distress and fear, and the law needs to keep pace with how it manifests.
And the punishment, also graded.
Yes. Graded for recidivism again. First conviction, imprisonment up to 3 years plus a fine. Second or subsequent conviction, imprisonment up to 5 years plus a fine. #4. Other offenses against women and marriage.
Okay, let's look at Section 79. This deals with words, gestures, or acts intended to insult the modesty of a woman. Sometimes the harm isn't physical force, right? It's about attacks on dignity.
Exactly. This section protects a woman's modesty and her right to privacy against intentional insults or intrusions that are conveyed through words, sounds, gestures, or even exhibiting objects.
So it's about penalizing behavior designed to affront dignity.
Yes, or to unlawfully invade her private sphere. The object is to penalize that kind of behavior.
What are the basic ingredients?
Whoever, intending to insult a woman's modesty, does 1 of 4 things. Utters any word, makes any sound or gesture, or exhibits any object intending that word, sound, gesture, or object to be seen or heard by her, or intrudes upon her privacy.
Intrudes upon her privacy. That sounds like it could overlap with voyeurism.
It could potentially overlap in some scenarios, yes. For instance, secretly placing a camera in a private changing room with the intent to view her undressed and insult her modesty might fall under both. But this section is broader, also covering things like lewd remarks or catcalling on the street, specifically intended for her to hear and feel insulted.
So what does this all mean for, say, daily interactions?
Well, it means the law recognizes that verbal and visual harassment, when coupled with that specific intent to insult modesty or invade privacy, is actually a criminal act. It upholds a woman's dignity as a fundamental right. Courts consistently hold that proving the specific intention is paramount for this offense.
And the punishment?
Simple imprisonment for up to 3 years and a fine.
Now let's turn to one of the most tragic and, frankly, horrifying forms of violence against women, often rooted in deep social evils. Dowry death, Section 80.
Yes, a very grim reality addressed specifically by the law. Section 80 severely penalizes dowry-related deaths of women. Its object is clearly to be a strong deterrent against the harassment and cruelty inflicted for dowry demands, especially when that leads to an unnatural death within the initial years of marriage.
It includes a crucial deeming provision you mentioned. What's that about?
Yes, that's key to its effectiveness. But first, let's look at the ingredients that need to be met for it to apply.
Okay.
First, a woman's death must be caused by burns, bodily injury, or, and this is broad, otherwise than under normal circumstances. This typically covers cases suspected to be suicide or homicide made to look like an accident.
Right.
Second, the death must occur within 7 years of her marriage. There's a time frame.
Okay, 7 years.
Third, and this is critical, it must be shown that soon before her death, she was subjected to cruelty or harassment by her husband or his relatives.
Soon before. How soon is soon?
That's often a point of legal argument, but courts interpret it as having a proximate link, a perceptible connection in time, not necessarily immediately before, but reasonably close to the death.
Okay. And the final ingredient?
Fourth, that cruelty or harassment must have been for or in connection with any demand for dowry. The motive has to be linked to dowry.
Okay, so if all 4 conditions are met, then what?
If all those conditions are met, the law deems it to be a dowry death. And here's the deeming provision's power. The husband or the relative who subjected her to that cruelty shall be deemed to have caused her death.
That deeming provision sounds incredibly powerful. What does it mean practically for getting a conviction?
It means the law essentially presumes causation under these specific circumstances. It shifts the burden. It makes it significantly easier to secure convictions in cases where direct evidence proving murder or abetment to suicide might be very difficult to gather, as these often happen behind closed doors.
Can you give an example?
Sure. Consider a woman dying from severe burns in her marital home, say 3 years after marriage. And there's evidence letters, testimonies from her family showing persistent harassment for more dowry happening soon before her death. The deeming provision allows the court to hold the husband or in-laws accountable for her death, even without direct proof that they physically set the fire. It presumes their actions led to her death under these circumstances.
And the punishment reflects this severity.
Yes. Imprisonment for not less than 7 years, which can extend up to life imprisonment. It's a critical legal tool specifically designed to combat this pervasive social evil.
Okay, the law also steps in to protect marriage itself, right? Section 82 deals with bigamy, marrying again while a spouse is still living.
Yes. Section 82 upholds the principle of monogamy, where it applies under relevant personal laws in India, which vary by religion, and penalizes the act of bigamy.
What's the object here? Protecting the first marriage?
Primarily, yes. To protect the sanctity and legal status of the first marriage, prevent fraudulent second marriages, and safeguard individuals, often women, from being deceived into entering a marriage that is legally void from the start.
So what's the basic offense?
It's straightforward. An accused person has a living husband or wife. They marry again during the lifetime of that spouse, and that subsequent marriage is legally void precisely because the first spouse is still alive and the first marriage is still valid.
And the punishment?
Imprisonment for up to 7 years and a fine.
Are there exceptions? What if the first marriage was annulled?
Yes, there are exceptions. If the first marriage has been declared void by a competent court, then marrying again isn't bigamy. Or if the former spouse has been continuously absent for 7 years and hasn't been heard of by people who would naturally hear from them if they were alive.
The 7-year rule, like a presumption of death.
Exactly. It's akin to a presumption of death for the purpose of remarriage. However, there's a critical condition attached. The person remarrying must inform their new spouse about these facts, about the previous spouse's 7-year absence.
Disclosure is key. Why?
To prevent fraud. What if the first spouse turns up later? The second spouse needs to know the situation. In fact, if the accused conceals the fact of the former marriage from the person they are marrying the second time, that's treated as an aggravated offense.
More serious punishment.
Yes. Concealing the prior marriage bumps the potential punishment up to 10 years imprisonment plus a fine. It directly targets the element of deception and fraud against the second spouse.
So what does this all mean? It's not just about marrying twice.
Exactly. It's about the legal validity of the marriages, the proper solemnization according to relevant laws, the ongoing validity of the first marriage, and, critically, whether there was deception involved in the second one. Proof of these elements is crucial for a conviction.
What if the marriage ceremony itself is a complete sham? A deception from the very start? Section 83 seems to cover this.
Yes, Section 83 punishes deceptive conduct where a person participates in a marriage ceremony dishonestly or fraudulently, knowing that it won't result in a lawful marriage.
What's the objective here? Protecting against fake ceremonies.
Precisely. To protect individuals from being deceived by sham ceremonies, which might be conducted for various nefarious purposes, and to uphold the integrity of the institution of marriage itself.
So what are the basic ingredients?
Whoever dishonestly or with a fraudulent intention goes through a marriage ceremony, knowing that he or she is not thereby lawfully married. The knowledge that it's not a real legal marriage is key.
Can you give an example?
Imagine someone orchestrating a completely fake marriage ceremony, maybe using someone impersonating a priest or official, or not following any required rituals, perhaps, for purposes like human trafficking, immigration fraud, or some other form of exploitation. They know the entire event is a legal nullity.
So it's not about a marriage failing later, but about it being intentionally fraudulent from the outset.
Exactly. That raises an important point.
Yeah.
The focus isn't on a relationship breakdown, but on the deliberate, fraudulent nature of the ceremony itself. The punishment is imprisonment for up to 7 years and a fine.
Okay, Section 84. Enticing or taking away or detaining with criminal intent a married woman. This sounds a bit archaic, maybe. Protecting the husband's rights.
It does have historical roots related to protecting the husband's perceived rights in the marriage, that's true.
Yeah.
But it criminalizes the act of interfering with a marriage by taking, enticing, or detaining a married woman with a specific intent.
What intent?
With the intent that she may have illicit intercourse with any person.
So what are the basics here?
Whoever takes or entices away or conceals or detains any woman whom he knows or has reason to believe is the wife of another man, with the specific intent that she may have illicit intercourse with any person.
And the punishment?
It's relatively lower compared to other offenses we've discussed, imprisonment up to 2 years, or a fine, or both.
Now, adultery itself was decriminalized in India, right? Section 497 of the old IPC. How does this section fit in now?
That's a fascinating point. While adultery as a criminal offense was struck down by the Supreme Court as unconstitutional, this section, Section 84 of the BNS, which corresponds to Section 498 of the old IPC, remains. Its focus isn't on the act of adultery itself, but on the interference by a third party. The taking, enticing, concealing, or detaining, coupled with that specific intent to facilitate illicit intercourse.
So it targets the third party's actions?
Primarily, yes.
Huh.
It's distinct from the decriminalized adultery offense, focusing more on the actions of the third party involved in the interference. Interestingly, historical interpretations sometimes held that the woman's consent to being enticed away didn't negate this offense, because the focus was on the interference with the husband's rights. But modern interpretations might view it differently, focusing perhaps more on the predatory aspect of the enticement or detention itself. It's a legally complex section with a complex history.
Domestic cruelty. A horribly pervasive issue. Section 85 provides a specific legal recourse within the marital home, doesn't it?
Yes, absolutely. Section 85 criminalizes cruelty inflicted upon a married woman by her husband or his relatives. Its main objective is to provide a specific legal remedy against domestic abuse, covering both mental and physical abuse and harassment, aiming to protect the safety, well-being, and dignity of married women.
What are the basic ingredients?
Simply put, the husband, or a relative of the husband, subjects the woman to cruelty.
And the punishment?
Imprisonment for up to 3 years, and a fine. Now, this section is very widely invoked in cases of domestic abuse in India. It's often used in cases involving dowry-related harassment, even when that harassment doesn't escalate to the point of meeting the criteria for dowry death under Section 80.
But that raises a crucial question, doesn't it? What exactly constitutes cruelty in the eyes of the law? It sounds potentially subjective.
Excellent question. And the BNS anticipates that. That's precisely where the next section, Section 86, comes in. It provides the specific legal definition of cruelty for the purposes of Section 85.
Okay, so let's unpack that definition in Section 86. How does the law define cruelty in this context?
Section 86 defines cruelty with a clear objective: to provide a solid legal understanding of what constitutes punishable cruelty within the marital context, removing ambiguity. It essentially has two main parts, or limbs.
Okay, what's the first part?
The first limb, Part A, defines cruelty as any willful conduct which is of such a nature that it's likely to drive the woman to commit suicide or R, to cause grave injury or danger to her life, limb, or health. And crucially, health here includes mental or physical health.
The inclusion of mental health is huge there.
Absolutely critical. It explicitly recognizes psychological abuse and its severe impact, not just physical violence.
Okay, and the second limb, Part B.
Part B defines cruelty as harassment of the woman, where such harassment is with a view to coercing her, or any person related to her, to meet any unlawful demand for any property or valuable security, or harassment because she or her relatives failed to meet such a demand.
So that directly links cruelty to dowry demands.
Exactly. This limb specifically targets dowry-related harassment as a form of cruelty.
Can you give an example of what might fall under this?
Certainly. Persistent mental torture, constant humiliation, insults, threats. Those could fall under Part A if they're likely to cause grave mental injury or drive her to desperation, and constant demands for dowry, coupled with threats or abuse if they aren't met, clearly fall under Part B, and likely Part A too if severe enough.
So it's not just about bruises.
Not at all. The law is explicit about including impacts on mental health and recognizing psychological abuse. This is really insightful because it gives clear legal teeth to forms of abuse that are often hidden, insidious, and don't leave visible scars, but can be just as devastating. #tag5. Offenses against fetal life and children.
Okay, let's shift focus now from crimes primarily against women to those affecting unborn children and very young children. Section 88 deals with causing miscarriage. How does the law regulate this?
Section 88 penalizes the act of voluntarily causing a woman with child to miscarry. However, there's a very important exception.
Which is?
It's not an offense if the miscarriage is caused in good faith for the purpose of saving the life of the woman. That's the key exception.
So the objective is to regulate abortions, preventing unsafe or indiscriminate ones.
Exactly. That's the object. To regulate terminations and prevent them outside specific legal and medical justifications.
What are the basic ingredients then?
Whoever voluntarily causes a woman who is with child to miscarry, and it's not done in good faith to save her life.
Does it matter if the woman causes her own miscarriage?
Good question. The explanation clarifies that yes, a woman who causes herself to miscarry is also covered under this section, subject to the same good faith exception.
Are the punishments different depending on the stage of pregnancy?
Yes, the punishment is tiered. For a general miscarriage caused unlawfully, imprisonment up to 3 years, or a fine, or both.
Okay.
But if the woman was quick with child, meaning the fetus has developed to a stage where its movements can be felt.
Quickening, right.
Yes, quickening. If the woman was quick with child, the punishment increases. Imprisonment up to 7 years and a fine.
Now, how does this interact with laws specifically allowing medical termination?
That's crucial. This section must always be read alongside India's Medical Termination of Pregnancy Act, 1971, MTP Act.
Yeah.
The BNS effectively criminalizes abortions that do not comply with the specific conditions and procedures laid out in the MTP Act.
So the MTP Act provides the legal pathway for abortion, and the BNS penalizes those done outside that pathway.
Precisely. And that distinction in punishment based on quickening is interesting. It reflects a historical legal view, present in many systems, that a fetus at that stage has a more discernible or developed form of life, warranting greater protection.
Okay, but what if that act of causing miscarriage is done without the woman's consent? Section 89 seems to cover this aggravated scenario.
Yes, Section 89 deals with the significantly aggravated nature of causing a miscarriage without the pregnant woman's consent.
What's the objective here? Protecting her choice.
Exactly. The object is to strongly protect a woman's bodily autonomy and her reproductive choices. It severely punishes forced or deceptive terminations of pregnancy.
So what are the ingredients?
Basically, it's committing the offense under Section 88, causing miscarriage unlawfully, but doing it without the consent of the woman. And importantly, for this section, it doesn't matter whether she was quick with child or not. The lack of consent is the aggravating factor.
And the punishment reflects that lack of consent.
Very much so. The punishment is significantly higher. Imprisonment for life, or imprisonment for up to 10 years, and a fine.
Life imprisonment is a possibility.
Yes. This section strongly upholds a pregnant woman's right to bodily integrity and her decision-making power regarding her own pregnancy. Forcibly administering a drug to cause an abortion or performing a procedure without her knowledge or against her will. That constitutes a profound violation under this section. If you connect it to the bigger picture, it reflects the paramount importance given to a woman's autonomy over her own body in this context.
What happens if an illegal abortion attempt may be intended only to cause miscarriage, tragically results in the death of the woman? Section 90 addresses this.
Yes, Section 90 penalizes acts that were intended to cause a miscarriage, but end up causing the unintended, though perhaps foreseeable, consequence of the woman's death.
What's the aim? Accountability for fatal outcomes.
Exactly. To hold individuals accountable for the fatal outcomes of illegal or unsafe abortion attempts. And the punishment is enhanced if the act was done without the woman's consent.
So what are the basic ingredients?
Whoever, with the intent to cause miscarriage, does any act which causes the death of the woman.
Does the perpetrator need to have known their act was likely to cause death?
No. And this is a crucial legal point highlighted in the explanation to the section. Knowledge that the act is likely to cause death is not essential for this specific offense.
So even if they didn't intend her death, but only the miscarriage, they're still liable if she dies as a result.
Correct. If their primary intent was the unlawful act of causing miscarriage, and that act leads to her death, they are held liable for the death under this section.
How does the punishment vary based on consent?
If the act causing death was done with the woman's consent, albeit consent to an illegal procedure, or if consent isn't specified as absent, the punishment is imprisonment up to 10 years and a fine.
And if it was done without her consent?
If the act intended to cause miscarriage, which resulted in death, was done without the woman's consent, the punishment mirrors Section 89, imprisonment for life or up to 10 years and a fine.
This seems targeted at dangerous, unsafe abortions.
Absolutely. It directly addresses the tragic outcomes often associated with back alley or unsafe abortion procedures. Legally, it's a form of constructive culpability, holding the offender liable for the death that results from their primary unlawful act, the intended miscarriage, even if death wasn't their specific intention. This significantly eases the burden of proof for prosecutors in such tragic cases.
Okay, Section 91 seems to delve into the very moment of birth. Act done with intent to prevent child being born alive or to cause to die after birth. What does this cover?
This section penalizes acts taken before birth that are specifically intended to either prevent the child from being born alive, which can be termed feticide in some contexts, or to cause the child's death immediately after birth, neo-infanticide.
So it's protecting the child right at the threshold of life.
Exactly. The object is to protect the life of a child at the very threshold of birth and immediately thereafter.
What are the ingredients?
Whoever, before the child's birth, does any act with the specific intention of either preventing that child from being born alive or causing it to die after birth. And D, does by that act actually prevent the live birth or cause the death after birth.
Is there an exception for saving the mother's life?
Yes, the same exception applies.
Yeah.
It's not an offense if the act was done in good faith for the purpose of saving the life of the mother.
And the punishment?
Imprisonment for up to 10 years, or a fine, or both.
How is this different from causing a miscarriage under Section 88?
What's fascinating here is the focus on the specific intent at the perinatal stage. Section 88 deals with causing a miscarriage generally. Section 91 targets acts done before birth, specifically aimed at destroying the child either just before it's born alive or immediately after. It reflects a strong legal protection for nascent lives at that critical point, balanced, of course, against the need to save the mother's life.
Taking the protection of unborn life further, Section 92 deals with causing death of quick unborn child by act amounting to culpable homicide. This sounds serious.
It is. This section penalizes the destruction of a quick unborn child. Remember, that's a fetus whose movements are discernible by an act that would have amounted to culpable homicide if that same act had caused the death of a person already born.
So it equates harm to a quick fetus with culpable homicide in certain circumstances.
In terms of the nature of the act, yes. The object is to provide a higher level of legal protection for a fetus that has reached the stage of quickening.
What are the basic ingredients?
Whoever does any act under such circumstances, that if that act caused the death of a born person, they would be guilty of culpable homicide. And they do, by that act, cause the death of a quick unborn child.
What's the punishment?
Imprisonment for up to 10 years and a fine.
Can you give an illustration?
The law itself provides a clear one in its commentary, effectively. Imagine someone violently assaults a pregnant woman, perhaps intending to cause her death or grievous injury, which would be culpable homicide if she died.
Yeah.
She's injured but survives, but her quick unborn child dies as a direct result of the assault. The perpetrator would be liable under this section for causing the death of the quick unborn child.
That raises an important question, though. How is quickening actually established?
That often relies heavily on medical evidence presented in court testimony from doctors, ultrasound records perhaps, to establish the stage of fetal development and whether movement would have been discernible.
Now, tragically, some of the gravest harms to children come from those meant to protect them. Section 93 covers exposure and abandonment of child under 12 years.
Yes. This section penalizes the desertion and endangerment of young children by those legally responsible for their care, parents or caregivers.
What's the objective? Protecting vulnerable kids.
Exactly. To protect vulnerable children under the age of 12 from the dangers of exposure and abandonment by ensuring that their caregivers fulfill their fundamental duty of care.
So what are the key elements?
The father, mother, or any person having the care of a child under the age of 12 years exposes or leaves that child in any place with the intention of wholly abandoning such child.
That intention to wholly abandon seems crucial.
It is. What's fascinating here is that focus on the specific intention of wholly abandoning. This distinguishes it from, say, accidentally misplacing a child or leaving them somewhere temporarily with the intent to return. It targets the deliberate act of severing care permanently.
And the punishment?
Imprisonment for up to 7 years or a fine or both.
What if the child dies as a result of the abandonment? Does this section prevent a murder charge?
No, absolutely not. The explanation to this section makes this crystal clear. A conviction under this section for abandonment does not prevent the person from being tried for murder or culpable homicide if the child actually dies as a result of being exposed or abandoned. This section is really a clear enforcement of the parents' patriae principle, the idea that the state has a duty to protect those who cannot protect themselves, like children stepping in to hold caregivers accountable when they abdicate that fundamental duty.
Sometimes desperate acts seek to erase the very fact of a child's existence, even after death. Section 94 covers concealment of birth by secret disposal of dead body.
Yes, this section penalizes the clandestine disposal of a child's dead body when it's done with the specific intent to conceal the fact that the child was ever born.
What's the object here? Punishing the cover-up.
Exactly. To punish the act of secretly disposing of the body in order to hide the birth, which might be done to evade social stigma, investigation into the death, or other consequences.
So what are the ingredients?
Whoever, by secretly burying or otherwise disposing of the dead body of a child, and it doesn't matter if the child died before, during, or after birth, intentionally conceals or endeavors to conceal the birth of such child.
The focus is really on hiding the birth, not necessarily how the child died.
Precisely. This section doesn't primarily focus on the cause of death, though other charges might apply there. Its core is the act of hiding the fact of the birth itself through the secret disposal of the body.
What kind of situations does this typically cover?
It's often seen, sadly, in cases of concealed pregnancies resulting in stillbirths or infant deaths, where the parents, perhaps driven by fear, shame, or social stigma, try to erase any trace that a birth occurred. It raises an important question, of course, about the broader societal pressures that might lead someone to such desperate acts, while the law itself firmly punishes the act of concealment. The punishment is imprisonment up to 2 years, or a fine, or both.
Okay, Section 95. This feels like the ultimate betrayal. Adults using children as tools for their own criminal ends. Hiring, employing, or engaging a child to commit an offense.
Yes, this is a truly powerful provision. It severely penalizes adults who exploit the vulnerability of children by using them as instruments to commit crimes.
What's the objective? Protecting kids and punishing the masterminds.
Exactly. To protect children from being drawn into criminality and to hold the adult orchestrating it fully accountable, treating them, in effect, as if they committed the principal offense themselves.
So what's the basic act?
Whoever hires, employs, or engages any child, defined here again as under 18 years of age, to commit an offense.
And the punishment.
It's significant. Just for engaging the child to commit an offense, the punishment is imprisonment for not less than 3 years, extendable up to 10 years, plus a fine.
Okay, but what if the child actually commits the offense the adult engaged them for?
Here's the real game changer, as you called it earlier. If the offense is committed by the child as a result of being hired, employed, or engaged, the accused adult who engaged them also gets the punishment provided for that principal offense, as if they had committed it themselves.
Wow, so it's not just aiding or abetting, it's direct liability for the main crime.
Correct. That's a huge leap in protecting children and deterring adults from using them this way. It essentially bypasses arguments about the child's own culpability, or lack thereof, and places full responsibility on the adult manipulator.
Does it mention specific types of offenses?
Yes. The explanation makes it explicit that hiring, employing, engaging, or using a child for sexual exploitation or pornography is specifically covered under this section.
How does this work legally, treating the adult as the main offender?
It effectively extends a legal principle sometimes called the innocent agency doctrine. It punishes the adult who instrumentalizes the child as if they were the principal offender. The explicit inclusion of sexual exploitation and pornography highlights the most egregious forms of this crime. If you connect this to the bigger picture, it reflects a very strong commitment to combating child exploitation and trafficking by holding the adult entirely responsible for the criminal actions they compel a child to undertake. It removes any potential legal shield for those who hide behind a child's vulnerability.
And linked directly to that exploitation, what about inducing a child into illicit sexual situations? Section 96, procuration of child.
Yes, Section 96 penalizes the act of procuring or grooming children for sexual exploitation, specifically targeting situations where the intent is for the child to engage in illicit intercourse.
What's the aim here? Stopping grooming.
Exactly. To protect children from manipulation, coercion, or luring into situations of sexual abuse.
So what are the basics?
Whoever, by any means whatsoever, and that's very broad, induces any child under 18 to go from any place or to do any act with the intent that such child may be, or knowing it's likely that they will be, forced or seduced into illicit intercourse with another person.
By any means whatsoever sounds like it covers a lot of tactics.
It does. What's fascinating here is that broadness, covering a wide range of manipulative grooming tactics, and also the clarity that the intended illicit intercourse can be with another person, not necessarily just the accused procurer.
So it targets the facilitator.
Yes. This makes it a critical tool against child grooming and trafficking networks, where the accused's core intent is to facilitate sexual exploitation by someone else. The intent is the key element.
And the punishment.
Imprisonment for up to 10 years and a fine. It's a proactive measure against those who enable or facilitate child sexual abuse, recognizing the insidious nature of grooming even before the final act of abuse might occur.
Okay. Section 97 seems quite specific. Kidnapping or abducting child under 10 years of age with intent to steal from its person, protecting very young children from theft via abduction.
Yes, this provides special protection to very young children, specifically under the age of 10, from being kidnapped or abducted for the purpose of theft from their person.
Why the specific age limit and focus on theft from the person?
The object is to deter predatory acts that specifically exploit the vulnerability of very young children, targeting those who might abduct them simply to steal something they are wearing or carrying, like jewelry.
So what are the ingredients?
Whoever kidnaps or abducts any child under the age of 10 years, with the intention of taking dishonestly any movable property from the person of such child.
And the punishment?
Imprisonment for up to 7 years and a fine. The age specificity, under 10, and the intent, theft from the child's person, are key here, distinguishing it from general kidnapping offenses which have different elements and penalties.
Now we confront the grim reality of children being treated as actual commodities. Section 98, selling child for purposes of prostitution, etc.
Yes, this section directly combats the trafficking and exploitation of children by penalizing those who treat children as commodities to be sold or disposed of for sexual or other unlawful or immoral purposes.
What's the main objective?
To protect children from being sold into prostitution, any form of sexual exploitation, or other unlawful and immoral activities.
So what's the prohibited act?
Whoever sells, lets to hire, or otherwise disposes of any child, with the intent that such child shall, at any age, be employed or used for prostitution, illicit intercourse, or any unlawful and immoral purpose, or knowing it to be likely that the child will be so employed or used.
At any age seems important there.
Very important. It ensures protection regardless of whether the intended exploitation is immediate or planned for when the child is older.
And the punishment.
Imprisonment for up to 10 years and a fine.
You mentioned a presumption earlier in relation to dowry death. Is there one here?
Yes, there's a significant presumption here, too. Explanation 1 states that if a female child under the age of 18 is sold, let for hire, or otherwise disposed of to a prostitute, or to any person who keeps or manages a brothel, the law presumes that she was disposed of with the intent that she will be used for the purpose of prostitution, unless the accused can prove the contrary.
That presumption sounds powerful, designed to help prosecutions.
Absolutely. It's designed to ease the significant evidentiary burden in proving specific intent in these very difficult trafficking cases, especially when dealing with vulnerable victims and secretive networks. This section really targets the supply side of child trafficking. If you connect it to the bigger picture, it aligns directly with international efforts to combat human trafficking, particularly child trafficking, by making it unequivocally illegal to facilitate the sale or disposal of children for these horrific purposes. The presumption is a practical acknowledgement of the grim realities of such transactions.
And as with any awful market, if there's a supply side, there's a demand side. Section 99 seems to target those who create that demand, buying child for purposes of prostitution, etc.
Exactly. Section 99 penalizes the demand side of child trafficking and exploitation. It punishes those who acquire children for sexual or other unlawful or immoral purposes.
So it complements Section 98.
Yes, the object is to deter and punish the act of obtaining a child for exploitation, working in tandem with Section 98, which punishes the disposing of the child.
What are the basic ingredients here?
Whoever buys, hires, or otherwise obtains possession of any child, with the intent that such child shall at any age be employed or used for prostitution, illicit intercourse, or any unlawful and immoral purpose, or knowing it to be likely that the child will be so employed or used.
Same at any age clause and knowing it to be likely standard.
Correct. And the same presumption applies here too. If a prostitute or brothel keeper obtains possession of a female child under 18, they're presumed to have done so with the intent for prostitution unless they can prove otherwise.
Now, what about the punishment for buying compared to selling?
This is where it gets particularly insightful. The punishment for buying is imprisonment for not less than 7 years, extendable up to 14 years, and a fine.
So the minimum is higher, 7 versus up to 3 for selling, or up to 10 if specific intent knowledge proven. And the maximum is also higher, 14 versus 10.
Exactly. The minimum mandatory sentence is significantly higher, and the maximum potential sentence is also higher for buying compared to selling under Section 98.
That does raise an important question, doesn't it? Does this reflect a legislative intent to punish the buyer, the demand side, even more severely, recognizing its crucial role in driving and perpetuating the entire cycle of trafficking?
It certainly seems to suggest that. By making the act of acquiring a child for exploitation subject to potentially harsher penalties, particularly that high minimum sentence, the law appears to be aiming to hit hard at the very root of the commercial child exploitation market, the demand that fuels it.
Wow. Okay. That was a truly expansive and sometimes quite difficult deep dive, wasn't it?
It really was. We've covered a lot of ground.
We really have. We've journeyed through these key provisions of the Bhartiya Nyaya Sanhita 2023, unpacking everything from that expanded definition of rape and the much more nuanced understanding of consent to the specific protections against things like sexual harassment, voyeurism, stalking, those very modern offenses.
Right, reflecting current realities.
And we also looked at those extremely stringent penalties, especially for crimes against child victims, the provisions on dowry death, and that horrifying world of child trafficking, both selling and buying.
What's truly fascinating, I think, when you step back, is how this legal framework really strives to be comprehensive. It seems to reflect society's, or at least the legislature's, evolving understanding of dignity, autonomy, and vulnerability.
It feels like a move towards being more victim-centric.
Definitely. There appears to be a clear move towards a more victim-centric approach, especially concerning women and children. You see it in the specific definitions, the way punishments are graded based on severity and vulnerability, and the incorporation of modern challenges like cyberstalking and image-based abuse.
The aim seems to be providing stronger legal tools.
Yes, robust legal tools for achieving justice and hopefully deterring these crimes. Of course, implementation is always key, but the framework itself is quite detailed. And it does raise that important question for listeners everywhere. How does your own legal system stack up against these kinds of challenges? What lessons, if any, can be drawn from seeing how another major system attempts such a comprehensive overhaul?
That's a really good point. So after exploring all these intricate legal provisions, these definitions, punishments, exceptions, you might find yourself asking a deeper question. While laws can certainly define crimes and prescribe punishments, what truly changes things in the, fundamental fabric of society? Can stricter laws on their own actually create the profound shifts in attitudes and behaviors that are necessary to truly eradicate these horrific offenses against women and children?
That's the perennial question, isn't it? The relationship between law and social change.
Exactly. It's definitely a question worth mulling over, maybe long after our deep dive concludes today.